Hey guys, this should be a relatively short one since it's only like a 4-page letter, and then I have to get back to work. But if you don't remember, on Friday, Blake filed her 10th sanctions motion. This was like after that expert deposition. There was a random hearing on Monday for an ongoing deposition. And it turns out it was one of the experts. The deposition had been postponed due to an illness. They had some sort of dispute, and then Blake filed for sanctions again over this issue they were having during the deposition. So even though it had everything to do with the expert deposition, as far as the sanctions they're asking for, she attached these letters from months ago regarding her deposition, which had really nothing to do with the issue at hand. And then there was also a bit of Jamie Heath's testimony, or his deposition, that they attached a transcript of, which was, I mean, I'm really not sure where they were trying to go with that. It did not make them come across very well, in my opinion. Ezra Hudson had a fabulous crash out, acting like a psycho. And if I have to hear 9 minutes one more time, I swear to God. I'm not really sure where they thought they were going to earn points there with that one. But when they referred to her deposition, Blake's deposition, in the letter they attached, this letter was from September. And it said something about Justin's attorneys asking about Blake's sexual history, alluding to rape shield laws, saying they can't ask her these kinds of questions. Now, the questions, they'll give us a little bit of information about what the questions were actually asking, though we don't have too much insight into what was asked during the deposition. As we know, like her pages and everything, she still has them all sealed. She asked again to extend the deadline for, arguing to keep things sealed or not. So that stuff's not even going to come out, if it does, until probably like early mid-January. So they did respond, though, to that sanctions motion that just came up. So I'm going to read that for you. Before we get into that, though, give me 1 second here to pull this up. I told people last night, this is something that I'm going to start doing. Just, it's good to have a backup because you never know. And I actually started streaming on Twitch. So now I've put my streams up on Twitch. So if you have it, if you could go follow me there, just in case, something happens with YouTube. Let me pull it up for you. So you can see it's the same username and everything right there. But yeah, so let me share this letter. We'll go through that, and then I'll go back to work. Okay, and I might not be, I said I was going to try to stream tonight. I might not be doing that because I got to go see a friend who's in town. So I'll let you guys know later. But let me move this around so it's easier for everyone to read. Okay. Quadruple, Lauren. Was it really quadruple? Huh. Okay. So they're writing in opposition to Blake Lively's motion for sanctions and other relief concerning the deposition of Nicole Alexander. Ms. Alexander is an expert in digital ecosystems, AI-mediated brand perception, and online reputation measurement. She was designated by the Wayfarer parties to rebut certain expert reports concerning whether the social media activity regarding Ms. Lively from August 2024 through February 2025 was caused by a coordinated negative manipulation campaign, as Ms. Lively alleges, or was the result of organic public engagement in entertainment industry media cycles. On December 15th, Ms. Alexander was deposed for 7 hours by Ms. Lively's counsel, Meryl Gavernsky. Is it Gavernsky? I don't know. About her expertise and her expert report. Okay, give me 1 sec, guys. Okay. Federal Rules of Civil Procedure provides that, let's see, an objection during a deposition must be stated concisely in a non-argumentative and non-suggestive manner. Under Rule 30d2, courts are authorized to impose sanctions for conduct that impedes, delays, or frustrates the fair examination of the deponent. Ms. Lively submitted to the court only 35 pages from Ms. Alexander's deposition transcript, a mere 10% thereof, presumably to create a false narrative. We submit here with the entire transcript so that the court can see that Ms. Alexander's deposition was not impeded, delayed, or frustrated. Upon reviewing the transcript, the court will see that the Wayfarer parties' counsel concisely and appropriately objected to the form of certain questions, did not utilize speaking objections, and permitted Ms. Alexander to answer every question except for one topic, which is addressed below. And they did attach that transcript, so let me show you here. It's not something we're going to go over right now. It's 188 pages here, but they have like 4 pages on every page down here, if you'll see. So like 6, 7, 8, 9. It's like I don't want to go through 188 pages times 4 right now. Plus I have to get back to my job, so I can't really do that. So that's something I'll go through later and like highlight a couple things, and we'll take a look at it later on, maybe Friday or something, because everything's gonna be busy Thursday, of course, and then tomorrow I'm not really sure what's going on. So anyway, here in the footnotes is where they kind of address this, the thing about Blake Lively's sexual history that she was complaining that they were asking questions about. As we know, that obviously did not come up during this expert's deposition. It's just something they wanted to put out for the press. They do this usually on Friday, late in the day. So the, TMZs and all those will pick it up. And then they go the whole weekend without being able to respond to it. I mean, sometimes they do file stuff on the weekends, but like, not usually, Okay. Omar's going to get major flooding. Oh, shit, is he? That sucks. Okay. So the footnote says, Miss Alexander's deposition had nothing to do with Miss Lively's sexual or romantic history. Nonetheless, the motion attaches a self-serving letter from 3 months ago sent by Miss Lively's counsel to the Wayfarer Party's counsel, complaining erroneously about certain deposition questions purportedly concerning her sexual or romantic history. The questions at issue therein pertain to Miss Lively's reputation, which she put at issue. Given that Miss Lively did not seek relief from the court months ago about any purportedly improper lines of questioning and is not seeking such relief now, the motion seemingly was filed solely to generate inflammatory headlines and falsely besmirch the character of the Wayfarer Party's counsel. And then they have those links to Variety here and page 6 saying Blake Lively's lawyers blast Justin Baldoni's lawyer's deposition behavior, say questions about her sex history should be off limits. And like, that's not what the expert deposition was about at all. But the headlines make it sound like this sanctions motion was somehow like relevant to Blake's deposition and it had anything to do with her sexual history. And the way they wrote it also makes it sound like this was about her deposition, which happened in September. So it's just kind of ridiculous. All right. Is this about the 9 minutes that Ezra crashed out about? So the reason that was so odd as well is like that was during Jamie Heath's deposition. So the crash out over the 9 minutes, also not relevant to the expert deposition. I have no fucking idea why they included that. And then, I've heard some lawyers say when they looked at that sanctions motion, like, okay, so attorneys, sometimes it will get a little heated, but then if one side acts in a way that's a little bit aggressive and then the other side responds in kind, but then only one of them is like running to the judge and complaining about it, like it's kind of whiny and annoying. You can't just go and act like that and then get upset when you like get the same behavior returned to you. So it's just kind of interesting, I guess. All right, one sec. Okay. The motion does not identify any material area of testimony Ms. Gavrnsky sought to explore that she was prevented from exploring by counsel's objections. Okay. We're going to skip that. That's a reference to a case. A review of what Ms. Lively labels frequent speaking objections demonstrates the triviality of the motion. Although Ms. Lively alleges that the Wayfarer Party's counsel interrupted the deposition to ask whether Ms. Alexander should review an exhibit, the cited examples show that A, Ms. Lively's counsel, Meryl Gavrnsky, was unaware Ms. Alexander had amended her expert report, erroneously claimed that the amended report had not been served upon her, it had been a month earlier, and the Wayfarer Party's counsel professionally steered her in the right direction. Okay. Ms. Alexander, who had never previously been deposed in any litigation, let alone remotely, was advised to download an exhibit so she can review the entire document as one would do in person, rather than review only the portions viewable to her, though Ms. Gavrnsky's screen sharing, like through the screen sharing. So she can only see what Blake's attorney is putting on the screen, so they're saying that she should download the exhibit so she can see the whole thing. Okay. Ms. Gavrnsky asked Ms. Alexander to summarize a lengthy article cited in the expert report, The witness was confused about whether she was being to summarize it offhand from memory, and when the Wayfarer party's counsel asked for clarity, Ms. Gavrnsky launched into a tirade instead of clarifying what she was asking Ms. Alexander to do. During one exchange cited by the motion, Ms. Gavrnsky interrupted the witness, who was confused by the line of questioning, and the Wayfarer party's counsel suggested that Ms. Gavrnsky listen to the witness so the questions could be clarified. Okay. Even if such, how do you say that word, dude? I don't know, can be liberally construed to violate Rule 30C2, which it should not. Violation of the rule is mitigated to some degree if the, okay. I can't even spell this. Colloquy? Okay. Just say conversation. Okay, whatever. Use your big words, that's fine. Let's see. Even if such colloquy can be liberally construed to violate Rule 30C2, which it should not. Violation of the rule is mitigated to some degree if the colloquy that occurred as a result of objections related to matters of clarification. So they're just citing another case there. Notably, at the start of the deposition, Ms. Gavrnsky failed to instruct the witness, as is standard in depositions, that if she did not understand a question, she should say so and Ms. Gavrnsky would rephrase it. As for Ms. Lively's criticism that Ms. Alexander was sometimes instructed to answer again, such instruction is not improper. Okay. Instruction to answer if you understood or if you can were not improper. Okay, so they're citing the case again. Examples of improper speaking objections are those made by Ms. Lively's counsel Ezra Hudson at the deposition of non-party Jenny Slate. And of course, this is unfortunately sealed. Otherwise, I would pull it up and read it to you right now. But apparently, Ezra Hudson made improper objections there. I don't know what happened there, so I can't really speak to that. But that's what they're alleging. So, I mean, I wouldn't be surprised. Ezra's an interesting lady. Okay. But God, that crash out over the 9 minutes was, wow. All right. Ms. Gavrnsky never instructed Ms. Alexander at the outset of the deposition that she could request a break, which is routine. Ms. Lively then nevertheless inexplicably takes issue with the suggestion after 2 hours of questioning that Ms. Alexander and the stenographer be provided with a break during the deposition. After such break was requested by Ms. Alexander's counsel, Ms. Gavrnsky proceeded to ask another question, then utilized the guise of a pending question as a basis to refuse a break, and ultimately was proven wrong when the stenographer confirmed that no question had been pending. In sum, the questioning of Ms. Alexander went relatively smoothly, except after the party's counsel conferenced with the court during a break, and Ms. Lively failed to show that the deposition was impeded, delayed, or frustrated in any substantive manner. The only time Ms. Alexander was instructed not to answer was based on privilege/work product and in connection with questions concerning her conversations with separate counsel, the identity of whom she was unable to recall about this case. Okay. In response, Ms. Gavrnsky improperly attempted to debate counsel during the deposition about the instruction to Ms. Alexander not to answer. In violation of Rule 4.c of this court's individual practices in civil cases, Ms. Lively's counsel failed to meet and confer after the deposition or even during a break concerning the propriety of the objection. The motion should be denied for that reason alone. Had Ms. Lively's counsel adhered to the court's individual practices concerning the resolution of discovery disputes, we would have agreed to a short continuation of Ms. Alexander's deposition via remote means and on a mutually convenient date, limited to questions concerning her communications with the separate counsel, identifying facts or data that such counsel provided to her, and that she considered informing her opinions expressed in her report. We so stipulate now. Okay. The motion to sanction... What the... My bad. Sometimes my phone will just do that. If I have a YouTube tab open. Give me one sec here. Yeah, I was just making sure I didn't miss anything. Okay. The motion to sanction Brian Friedman and the undersigned is frivolous because it is based upon an alleged ongoing pattern of deposition misconduct, but cites no prior conduct by either attorney at any deposition. So, the undersigned is Kevin Fritz. So they're trying to sanction Brian Friedman and Kevin Fritz. You know, they love to try to sanction Brian Friedman. So there's still another pending sanctions motion for that. So give me 1 sec. Wasn't Blake's deposition at the end of July? Maybe it was. Honestly, it's been months, so I don't remember. But the letter about it, the letter they apparently sent about it was in September. So I would assume it was in September, because why the fuck would they send a letter about that? Well, then again, nothing else they're doing makes sense. So maybe it was. I don't know. Maybe her deposition was back in July. I don't know. I know it was supposed to be. It got delayed a couple times. So I can't remember exactly what date it was. But the letter they sent that was being cited in her sanctions motion was sent in September. So, all right. Hey, Bruce, what's up? Okay. Furthermore, the motion cites cases in which the attorney deliberately violated repeated orders of the court, engaged in prolonged and unnecessary argument regarding the relevancy of a simple question, and instructed the witness not to answer on relevancy grounds, or was held responsible for its client's violation of orders to produce documents, none of which Ms. Lively even alleges or demonstrates that either Mr. Friedman or the undersigned did. The only ongoing pattern is Ms. Lively's use of the media to disparage others and distract the public from the legal issues at hand. Okay, so look at the footnotes here. It says, ironically, it was Ms. Gavernsky's own improper attempt to debate counsel during the deposition that prompted Brian Friedman's request to her that she cease such misconduct. The citation to Jamie Heath's deposition transcript concerning an entirely different situation where counsel was not responding to any pending question but raising concerns about lengthy breaks that Ms. Lively's counsel was taking. So the Heath deposition is where I believe that's where the whole 9 minutes thing came in. At one point in one of those documents that she attached, it showed that Jamie Heath had to leave the room because Blake's attorney was trying to disparage his character about a former client of his, talking about a former case he had taken, which is very strange behavior. If you ask me, I don't think you're supposed to do that in a deposition, but hey, what do I know? I'm not an attorney. But it seemed really, really strange. Am I right to assume that Miss Merrill was the one representing BL against Perez Hilton? Honestly, I don't remember. I know she's been involved in Andy's case, so not sure. All right. So that's all I got for now. Like I said, I don't know if I'll be back tonight. I'll do something tomorrow, probably during the day, because usually we get off work early on Christmas Eve, day before Thanksgiving, stuff like that. So I'll probably be in the afternoon again. But I couldn't tell you what time yet. So most likely I'll be back tomorrow. If I end up doing something tonight, I'll let you know. But like I said, I got some stuff I want to do tonight. So thanks everyone. If you could hit the like button for me, I'd appreciate that. And I will see you all soon. All right. Bye.